Right. Good morning, ladies and gentlemen. Welcome to another episode of PLA with myself and Bruno. And then today, Nick has not joined us today, but we do have a familiar yet a very rare face during these busy times with Cilna. So thank you, Cilna, for joining us today. And we've got two questions today. One will be dealing with the late estate, and the second one will be dealing with hijacked buildings. Bruno, we're going to be jumping in quickly with your question, which is the late estate one, right? With this one, what the question states is that there is a property which is in the name of the mom and the dad. They bought this property, the parents, on behalf of a daughter, which now stays there, right? And then there is a cottage on the property that the daughter now wants to let out or rent out, right? The mom and the dad have now passed away in the span of a year, and the daughter has been actually appointed as executor of the estate, right? The question she has now, Bruno, is that can the rental income from the property actually go to her as the daughter, or must it go into the estates until that process is then wrapped up? So Bruno, maybe
Sure.
just yeah.
Cool, awesome, thanks. So the first thing to try and understand over here is the fact that the mom and dad passed away obviously means that the property needs to be dealt with in a very specific way. So we do need to understand that those laws would typically apply. Now, you mentioned that it was bought on behalf of the daughter. The problem sometimes with these informal arrangements about being bought on behalf of, and forget the familiarity, the fact that it's the daughter and, like, the father, the parents. When somebody speaks about being bought on behalf of, I'm entitled to, it starts becoming a little bit difficult, because the question doesn't specify anything about there being brothers and sisters, as an example. So we need to now factor in the reality that family, it's not always this simple. Bought on behalf of doesn't mean that the person is entitled, because you might not be able to prove that it's actually been bought on your behalf. So unless there's something in writing, I normally tend to scrap that and go, look, let's try figure out what the will actually says. And if there is no will, let's try see what the interstate law says. Interstate law is just basically the default position. If there isn't a will, interstate law allows for, the legislation has basically determined or set a default on how assets are supposed to be dealt with. So that's something that needs to be borne in mind with this. So then we move on to the second part of the question, assuming naturally that she is ultimately entitled, that both estates are going to be wrapped up, and that she is the sole heir of these estates, both the heir and the executor. In those instances, then there shouldn't be a problem at all, because our law does allow for the beneficiaries, the heirs, the legatees, or whatever you want to call it, it does allow for them to benefit from assets and income while their estate is being wound up. But obviously, this is normally in situations where the executor consents to it, bearing in mind the need for finances and these beneficiaries actually receiving income. Again, if there's brothers and sisters, you might find that there might be a bit of a challenge, because why would she be able to benefit from the income of the property and her siblings not? So it does depend on the circumstances, depends on the will or whether it's interstate, and whether there's any other facts that we might not have before us. Cilna, do you have anything that you want to add?
Yeah, I think I think you've covered it completely, but I think the one thing that I would like to add is I have seen quite a few instances where a situation like this arises, and you sit with a deceased estate and its parents, or exactly like you said, spouses or life partners or whatever.
Right.
And the assumption is very often, it's okay for me to move ahead with this because this person would have been okay with me having the money. The problem is, legally, being okay with you having the money doesn't necessarily suffice, and you could end up in a very, very unfortunate situation where you've received income from a property which you were not entitled to. And even if you did something then like pay the bond, or even if you did something seemingly very bona fide, you could end up in a situation where you might have to refund that to the estate. So I think this is one of those questions where I would say really err to safety side. And if you're in a situation like this, pick up the phone, call SSLR, call BSA, we're there for a reason. Because you could, the answer could be very simple, and we could just be like, no man, it's fine. Do you. But if that's not the case, the consequences could be quite massive. So I think for safety's sake, pick up the phone, we're there for a reason.
Absolutely.
Yeah. So thank you guys for covering that. You did do a question quite some justice.